want to wax a little philosophical here. Do you think a person's race should be used to harm that person?
No, Senator.
How about you, Judge Ramirez?
No, Senator.
Okay. Judge Yalba, do you think that a person's race should be used to help that person?
No, Senator.
Okay. How about you, Judge?
No, Senator.
Okay.
Thank you, Senator Cotton. Senator Kennedy.
Thank you, Mr. Chairman. Judge D'Alba, Judge Ramirez, congratulations to you both. Judge D'Alba, do you think, I want to wax a little philosophical here, do you think a person's race should be used to harm that person?
No, Senator.
How about you, Judge Ramirez?
No, Senator.
Okay. Judge D'Alba, do you think that a person's race should be used to help that person?
No, Senator.
Okay. How about you, Judge?
No, Senator.
Okay. Judge D'Alba, why is that?
Well, as a legal standard, Senator, we try to look at people just based on either, if we're in a criminal position, we're looking at them for what they've done. In a civil matter, it usually doesn't come into account. So, and also it's something they don't necessarily control, so it seems unfair.
Okay. Judge Ramirez?
The Constitution provides for equal protection for all.
Okay. Judge D'Alba, this has been in the news a lot lately, and you'll probably see it if you're confirmed to the Court of Appeal. Tell me about the dormant Commerce Clause.
Senator, I'm somewhat familiar with the Commerce Clause, which is found in Article 1 of the Constitution.
Well, it was a big Supreme Court case that just came out of your state.
And I apologize, Senator. In my 11 years of practice and my 5 years on the bench, I have not dealt with the dormant Commerce Clause. But if I am so fortunate enough to be confirmed and have to deal with it in the future, I would certainly research it and, be prepared.
All right, then just tell me about the Commerce Clause in general.
So my understanding about the Commerce Clause, like I stated, Senator, is that it is under the Article 1 of the Constitution, and it allows the legislature to create laws that allow for movement and things related to commerce in the United States. So anything crossing state lines, things like that.
So it allows Congress to regulate commerce.
Yes.
Between whom?
Between states, for example?
Mm-hmm.
Yes.
Anybody else?
It's not coming to mind right now, Senator.
Okay. All right. You're familiar, Judge, I'm sure, with the Fourth Amendment and the warrant requirement. What's, just for the record, what's the warrant requirement?
The warrant requirement requires, so Fourth Amendment says that we are not subject to unreasonable searches and seizures. So in order for someone to, for example, enter our home, there needs to be a warrant. And in order to get a warrant, an officer has to, under oath, state that there is probable cause to believe that either a crime has been committed or there is a crime afoot, and that they have to describe with particularity the place to be searched.
And that's based on the Supreme Court's interpretation of the U.S. Constitution, correct?
Yes.
Okay. Let's suppose that Florida passed a law and said, we don't agree with the Supreme Court's interpretation of the Constitution and the Fourth Amendment and the warrant requirement. We're really concerned about the power of the state. And we're going to ignore the warrant requirement that no police officer has the right to come in your home, probable cause or otherwise, unless you agree to it. Would that be legal?
Well, Senator, I'd have to, it's somewhat of a hypothetical question, but I would
have. It's a very real question. It happened before. Would that be legal?
I would have to look at it a little bit more carefully, but, on first blush, my concern would be that under the Article 6, the U.S. Constitution is the supreme law of the land.
Yeah.
So we have to follow it.
What if Florida said under the state constitution, we're doing this? Does the U.S. Constitution always, or the Supreme Court's interpretation of the U.S. Constitution always prime a state constitution?
I have not dealt with that issue
Well,
in
there's a big case out of your state that deals with this issue.
it.
You familiar with the Pruneyard case?
The Pruneyard case I am familiar with.
Tell me the holding of that.
The holding of that was, it had to do with individuals who wanted to,
Yeah, but just tell me the holding. I remember the facts. Tell me the holding.
the holding was that the takings clause didn't apply to individuals outside of a shopping center who wanted to protest or
Yeah, but the point I'm trying to make is that the U.S. Supreme Court in that case said that the California Constitution primes the federal Constitution, didn't it? Isn't that what it said?
Yes, Senator.
So you want to go back to your answer about the Florida hypothetical I gave you?
As I stated, Senator, if I had a little more time to look at it and really think about it, I would
Okay.
be able to come up with something.
Thank you, Judge.
When Senator Kennedy asks the question quietly, slowly, deliberately, do you think a person's race should be used to help that person? And both nominees answer no, without hesitation, in the immediate wake of also answering that race should never be used to harm either. What you are witnessing is not culture warfare. It is not online noise. It is the ancient constitutional dilemma dragged back into the center of American law. The moral and structural question of whether the state is ever permitted to sort citizens into categories before the law. That simplicity is what makes this clip so devastating. That simplicity is why the room feels tense, even in silence. Because Kennedy forces the conversation out of abstractions and statistical engineering, and into first principles, into the realm where the American system either stands or falls. If we believe in equal protection, then law has no business picking which human beings get advantage or punishment based on race. If we believe in equal dignity, then the state cannot decide identity is a lever to pull for outcomes. This is not about ignoring history. This is not about pretending inequality is imaginary. This is about the core legal foundation of a republic. Justice may not be allocated by category, and it is striking, even stunning, that these nominees, in that moment, knew the moral truth instantly. Yet when Kennedy moved them from philosophy to doctrine, when he shifted from equal protection to dormant commerce clause, to supremacy, to the gap between state constitutions and federal interpretation, when he asked them to apply principle to structure, they stumbled. They could speak moral clarity in the abstract, but the institutional machinery of the system, the case law, the constitutional relationships, the case law memory, was vague, unsure, hesitant. That is the deeper narrative of this hearing. It is not that these nominees are unintelligent. It is that our legal culture has been trained to speak moral slogans faster than it can defend the architecture that morality requires to survive. Kennedy forces that exposure, because if judges cannot articulate the structural armature that protects rights, that is exactly how rights dissolve quietly underneath them. If the dormant commerce clause, a foundational implied constraint on state power, is unknown to a judge elevated to appellate review, what other constraints will be forgotten? If the supremacy of the Constitution over state constitutions in criminal procedure is not automatic in their mind, what future cases will drift? If the holding of Pruneyard, one of the most important federalism rulings of the modern era, cannot be recalled in the moment, what other guardrails will be soft-coded into ambiguity and eventually lost? This is how a nation loses equal protection without repealing it, not with a dramatic reversal, but through slow institutional amnesia. This is the moral message of this clip. Because when Kennedy begins with race, the most radioactive political subject in America, he begins on the moral plane. He begins where universal conscience exists. Race should not be used to harm. Race should not be used to help. Race should not be government's calculator. Both nominees agree instantly. But then Kennedy transitions into doctrine, because morality without legal structure is ornamental. It is symbolic. It is fragile. The Constitution is not kept alive by feelings or good faith. It is kept alive by the capacity of those entrusted with power to articulate, recall, and defend the structural limits that prevent power from bending morality into weapon. This is why hearings are not performance art. This is why judicial philosophy matters. This is why the details matter, because the details are where freedom either gets defended or lost quietly in the footnotes of rulings that no one understands until it is too late. And this is why conversations like this must remain public, must remain visible, must remain documented, because a nation that treats the Constitution as a brand instead of a blueprint is a nation that will wake up one day and realize that the blueprint is no longer controlling anything. Senator Kennedy is not simply interrogating nominees here. He is interrogating the republic itself. What does equality actually mean in practice? What does equal protection actually defend? What does judicial responsibility actually require? This is the closing truth. Free nations do not die in revolution. They die when those responsible for protecting liberty cannot articulate why liberty must be protected at the structural level, and how. That is why we document this. That is why this channel exists. That is why this clip matters. Because equal protection must remain real, not aesthetic. This is Liberty Congress of USA. Subscribe and stand with us as we continue exposing the real battle not between left and right, but between systems that protect freedom and systems that slowly forget how.